Peace, love, and law. There's a public notice. Chandon here from Orange Walk Town in Belize. I put together something entitled it Understanding Trust, Commerce, and the Role of Beneficial Interest in Public and Private Law. Now this comes from at least 3 years of studying this. And it's something that I feel that needs to be shared. So this was prepared mainly for public authorities and government administrators of Belize. The purpose of this is just to clarify the foundational concepts of trust law, commercial instruments, and equity in relation to public governance, the Crown, and the people's rights, or the rights of the people. So I'll start off here at the introduction. This document is prepared to assist public officials in understanding how legal fictions, trust law, and commercial agreements, and the equitable doctrines of beneficial interest intersect. By enhancing our collective understanding of these core legal principles, we can ensure a higher standard of public trust, administrative transparency, and fiduciary responsibility. So we hear the politicians, the ministers, these officials speak a lot about they are still going to continue serving the people and promoting transparency, which is great. However, their words do not align with their conduct. Conduct is what shows intent. So this right here obviously is just to reach out to public officials to reconsider what they think they know and review what they know in order for them to make adjustments. Now, I'm not saying I know it all, but this is based on me asking a lot of questions and reaching out to public officials only to find out that they do not understand how trust law works, how it interacts and intersects with commerce. They don't understand these things here, and I don't blame them. This is not something that is easy to understand. I myself found it very hard to understand until I got so submerged into the topic and so drowned in the whole subject of law that I was able to understand a little bit, comprehend a little bit more. And that's what I'm doing through this process right here, through this public notice. And this leads me to number 2, legal fiction and the person. Now if you read the laws of Belize and the legislative laws, you'll see that it mentions the word person very frequently. It barely says man, people, and more says person. So the laws apply to persons mainly. But what is that? Well, in law, the term person does not necessarily refer to a living man or a living woman. It also refers to something called an ens legis. Now, if you look up what that means in a law dictionary, you'll find that it is defined as a creature of law. It is an artificial legal entity created for the purpose of managing rights and obligations. So it's kind of like when you register a company, right, and you bring it into an existence, and you say the company is now called Bob's Auto Parts, right? So Bob's Auto Parts is going to be recognized in law once it's registered and has its its charter and its incorporation. Then it's recognized upon that certificate that it is an entity. That entity is a person. Bob's whatever would be a person, but he in law he's known as an ens legis, and that company is now going to be responsible to answer to the regulatory body of the public, which is the government. But its purpose is to manage the rights and obligations which it receives to fulfill. So this includes corporations, states, public agencies, and even a man's legal identity under statutory law. That would be the birth certificate name or the birth certificate person, which is like a sole proprietor. So your birth certificate person is a unregistered sole proprietorship, and when you register it, now it is a registered sole proprietor. And when you look into that, what that means is that you are holding all liabilities for that entity. Now, if you create a limited liability company, an LLC, well, you separate yourself. You're no longer liable. Now it's the entity is going to hold that liability, not you. You just might manage it, you might direct it, you might hold some capacity and title under that company name and company structure, but it's not necessarily the fact that you're going to be holding liability for that company at all. So, key insight: a living man or woman may operate within the legal system via their legal person. Listen to that, they're a legal person, because your birth certificate is legally a person and you can operate as that person. However, the legal person is distinct from the living being and functions purely in the realm of law and commerce. What does that mean, in the realm of law and commerce? Well, in the realm of law and commerce, that exists on paper or on the records. So if you have a company and you are recording and accounting for your activities, everything that you account for is on the records, and it is going to be known as it being in the world or in the domain or in the realm of commerce and law, because now it is in the jurisdiction. So it exists on paper. It's kind of like Facebook exists in its own realm, right? We use an avatar or a person to interact through that Facebook medium, and that Facebook world is outside or distinct from the real world. We can't go into Facebook, and in Facebook, in that world, Mark Zuckerberg, he's like the king, right? He's the king. Can't change that. That's Facebook world. So the facts of Facebook will be everything that is in the records of Facebook on how the authority is set up in that realm. That's facts. So in the realm of out here, there we have something called a record, the world of records and the world of paper. And that world of paper and records, what you see is these entities that exist that are birthed on these papers, and they're basically fictitious entities. And that's the world of commerce. That's the paper world of commerce. So now we go into number 3, the crown and the trust-based governance. Now in Belize, as in other Commonwealth jurisdictions, authority is conferred by the crown. By the crown. Listen to that. And there, why is this light here like that? Oh, man. This damn light. So, and the crown itself is a legal fiction. The crown is a legal fiction. It's not a real thing. You can't bring that living man or woman and he's crown. No, he represents. He's a fiction. He is what represents the whole royal family, I would say. The business of the royal family. So now, a symbol of enduring sovereignty and trust. It is a symbol, because it has to be, and we'll get into that right now. The crown itself is a legal fiction. Okay, under the Constitution of Belize, the crown delegates, meaning those who are receiving the title of the crown, they have an authority to the executive. The crown delegates authority to the executive. They delegate authority to the legislative and to the judiciary. So the crown delegates its authority to these 3 branches. All these 3 branches receive that delegation of authority from the crown. Not the people, the crown. I'm saying the crown. Now we got to get into that. Now, from the perspective of trust law, right, the crown can be understood as a grantor or settler, because the crown is what's giving the authority. The crown is what's granting the authorities, granting those duties and responsibilities over to these different branches. So the crown is the grantor. Now these other agencies, they become, or these branches, they are now trustees or protectors or hold some type of fiduciary role. Right? So now the trustees, That would be the various branches of government and public officials. Protector, that would be the courts. Constitutional offices like the Governor General, the Auditor General, etc. Beneficiary. Now, it would be nice if this was true, but it should be people of Belize, right? The people of Belize, not the persons. It should be the people. There's a distinction between persons and people. The people operate in commerce using their person. People can't be in commerce without their avatar, without their person. It's just how that works. Now, the Crown's powers are granted for the public benefit. And here, listen to that, the public's benefit. But this is implying, right, that the public is the people, right? Well, that's what it implies. But there is something a little bit more that needs to be understood before making any conclusions there. But we'll get into that. However, when an individual fails to assert their beneficial rights or to express a trust regarding their property, those rights may be treated as abandoned and claimed for public use. So basically, look, you have rights. Rights are properties. Everybody knows that rights are properties. You can buy rights, you can sell rights, you can trade rights, transfer it, convey it. You can, through a power of attorney, you can transfer that to an attorney, right? Rights is a piece of property. Now, what do you do with this property? What knowledge would you have to have in order for you to know what to do with that property, how to properly utilize that property, or how to secure that property, how to even assert rights to that property? Well, you need to know property laws or property rights. So that's where we must try to gain some knowledge in before understanding all this about the whole governing system, how it holds a beneficial right over the people because the people do not make claims to their properties. So if you don't claim your property or rights, if you don't know how to do it by your conduct, then it will be interpreted as you don't have anything to claim. Therefore, you're using a benefit and privilege from the government. So you don't have rights? Okay, that's no worry. The government will protect you and secure you because you poor little thing don't have no rights. You're like a godless creature. So the government will adopt you, and which was a ward of the state, and now they get to say what is good for you. Vaccines are good for you. You need to take those vaccines, Taxes, you got to pay taxes. It's good for you. It's good for the people. But it's because lack of property rights or knowledge of property rights is what does that to us. Anyway, 4, commercial contracts in fiat currency. Modern commerce operates through promises, through negotiable instruments and fiat currency. All forms of modern legal tender are promises to pay, backed not by gold, not by silver, but by the trust and labor of the people. So fiat currency itself is a promissory note. Right? So that's the Belize money. It's the central bank paper dollar. So in itself, it is a promise to pay. And it's also a commercial contract because we're using it in trade and exchange and commerce. And if I offer you a piece of paper, which is known as fiat currency, I'm making an offer in commerce, and you can accept it or you can reject it. Most people, obviously, you give them that promissory note from the bank because there's so much trust in it. They will accept it, and acceptance gives value to that instrument and makes it negotiable. That's why it's negotiable, because you can negotiate. You can say, hey, do you want this promissory note right here, this promise? You want this promise? You want this promise? And we're like, yeah, I want that promise. But we look at it as money, as something of value. It is no value, it just represents a value. But these contracts can become securities when monetized or securitized. What does that mean? If a security is basically something that you offer whenever you're making a promise. Because if you're making a promise, you say, "Hey, man, I promise to give you $1,000 within 3 months' time." Okay, that's good. Anybody can make that promise, but what do you have to back up that promise to make me feel a little bit more secure that you are going to fulfill that promise? You say, "Okay, well, I give you not only $1,000 that I'm going to pay, I'm going to give you a little bit of interest." And check this out. I got a title to my motorcycle right here, right? I'm going to make an agreement with you. This is what I'm going to do. I'm going to give you the title. I'm going to give you rights to the title. And you are able to claim this motorcycle as yours if I don't pay you. I'm borrowing $1,000. My motorcycle is worth about $3,000. So what I'm going to do is that just to make you feel better, I'm going to give you the rights. I'm going to promise to hand over the rights to the bike, to the motorcycle, to secure it, to make you feel secure, and I'll attach that to that promise to pay. So I'm going to give you a promise to pay. I'm going to give you some interest. Yeah, I'm giving you rights to collect interest on me or on my person. And for you to feel even more safe, I'm going to give you a security. I'm going to even throw in the title of my motorcycle, but I'm just gonna throw it in there as a just in case. I'm gonna put it as a collateral. If I don't pay you, I can't pay you. Guess what? You keep the bike. You can come collect it. You claim it. Here's a piece of paper that says I handed it over to you. If I don't pay you, I didn't pay you. Here's a bike. Here's a motorcycle. You can now have it. In exchange, just zero my account. I don't owe you the $1,000. I lost my bike. You got your bike. You got my bike worth over $3,000, so we're good. So we secure the obligation. The obligations are on the contracts, and the contracts basically can be utilized as a financial instruments because you can attach things to it like securities and interest. You can attach an interest to it. So you can attach these rights in commerce. Number 5, equity, substance over form. Okay, in equity, now if you don't know what equity is, I would suggest you do a little bit of digging around. There's a lot of information. Equity is just, under natural law, it's what's right and what's just. And equity operates in every single courtroom, especially here in Belize. In equity, substance is superior to form. What does that mean? In equity, substance is superior to form. I'll tell you that right now. I'll explain that. But regardless of the appearance of a document or instrument, what matters is an intention and effect. Equity sees that as done which ought to be done. Therefore, if a contract is entered into and subsequently treated as a trust instrument where the living man assigns the beneficial interest, that declaration must be respected. What does all this mean? What the hell is this, right? Okay, so equity regards substance over form because I want you to think about it like this. Remember, back in the days, the banks, they used to print out these forms of money, which are negotiable instruments, but very similar to right now, but they were backed by substance. They were backed by gold and silver, meaning that you can exchange it all day, publicly and privately, that piece of paper, that promise to pay, but you always had the option to say, you know what, I don't want to exchange this anymore. I actually want to redeem what this piece of paper is actually worth. It's worth value in gold and silver. Okay, great. So it has some backing because it's backed by substance. Why? Because in order for the bank to print out those fiat currencies, that IOUs, the reason they print out an IOU is because they have the gold. So they are not, the merchants back in the days would not want to carry the gold and silver all over the place with them, so they would store that. They would put it they would entrust it with another merchant, and this merchant would hold the gold, which is the substance, and then out of that substance he would create forms of money that represent that substance. So the representation of that substance would be that pieces of paper, those currencies. So currency, money, is a form of value. It represents it. So this is why in equity, it regards substance over form. because form would not exist, would not have any life, any reason to exist if there is no form that it represents. It's like the menu representing the food. If we didn't have no food, there'd be no menu to make any representations. And the menu is not the food. The menu is the form. The food, the actual substance, is regarded as superior. So that's what it means by equity regards substance over form. So therefore, at the moment right now, if you want to redeem those pieces of paper, those IOUs, those promissory notes, the central bank notes, and you take it to the bank and you redeem it for gold and silver, for some substance, there ain't none. Ain't got none. They'll just give you a credit. And credit, again, is just something you give when you have no money. There is no money. There is no money of value. So why do we look at money, at currency, as something of value? And why does it have any value? Well, the only reason it has value is because we exchange our time and energy for it. And when we get those pieces of paper, right, they have no value. But we charge it up like a battery when we say, I will accept it based on trading my time and energy for it. So that charges up the instrument. So every time we transfer that instrument by giving it to, taking a $20 and giving it to a bank, giving it to a gas station, that we are charging it up. We're telling, hey, you can use this. It has value. Why? Because I gave time and energy in exchange for that. That's why that has value. So that represents my value, represents a substance. That form represents substance. Substance is regarded as superior to form. So I hold a right, which is what? I get to benefit from that piece of form, paper, that fiat currency. I get to benefit because I put in the time, energy, and labor. I put in the substance. Remember, gold and silver was taken out of circulation, but it was replaced by another form of another substance, which is the original substance, which is labor, time and energy. So time and energy, labor became gold. That's why we're all private bankers, because we hold a substance. And we can create forms of money, which is I promise to pay. If you look at the promissory notes of the central bank, it's a promise to pay. And when we write I promise to pay, they're both promises to pay. And they're both backed by the same thing. Only thing is that one of them, it has a type of trusteeship and relationship already set up in a way to where the government and the bank are involved. But when we write it, it's just us between the other party. But either way, when we accept those instruments, we become a party to it in such a way that we are the only ones providing substance. The bank is not providing any substance. The government is not providing any substance. They don't have any substance to offer. All they have is forms and performance, banking performance, accountability to accounting. They have those duties and responsibilities, but they don't have the substance. We have to give it to them. We have to give them rights to that substance. That's what you call, we have the beneficial right, and we have beneficial ownership of these different pieces of property called movable properties or chattel paper or whatnot. Like contracts, number 6, contracts, trust, and beneficial ownership. Now, in everyday scenario, right? Like example, utility agreements and mortgages, let's say. Individuals enter into contracts that create an obligation, right? You sign a paper. Now you sign this paper, this agreement. That creates an obligation for your person because you're signing for your person. Your person now is holding that. But remember, if you haven't done anything with your person is a sole proprietorship. So now your sole proprietor is in need of somebody who's going to cover the liabilities, and it's only going to be you. So how are you going to cover your liabilities? So what you do is you have to secure the obligations of your person. You got to do that so that it removes the liability off of you, and you discharge it to some other entity or some other party. But behind these obligations lies a deeper commercial process. Now, these contracts, any contract that you sign, any valid contract, are often used as assets in a financial system. They're used as, what does that mean? We'll go over it. Now, they may be bundled, right? So if you got, like, let's say the utility company has all these customers, right? and every customer has to sign a service agreement or some type of agreement. All those agreements are contracts that imply an obligation of a person paying or promising to pay another person, and that contract, it's your person agreeing to pay Billy's Electricity Limited. Now that creates a contract, but that contract, they can bundle all of their contracts from this year, right? All these new contracts, and they bundle it up. And what they do is they do something called securitization. They securitize it in such a way that they can raise capital. They can raise money. How is that? Well, if you go to the website of BEL, you can find more information in their document section. You'll see that they talk about debentures. Debentures are secondary marketable securities. So basically they can create these different things, these debentures, and they can offer it to the public and sell it. It's basically like people will buy these pieces of paper, right? And they will provide they'll provide money, which is the Belize bank notes. So the company's getting these monies for selling these pieces of paper, debentures. But then why is those debentures, why are they valuable? Because they're backed by the contracts that they bundled up. And say, look, we can pay that because, see, we have these other people right here that they are promising to pay. So they're promising to pay. There's all these contracts they're promising to pay in the future. So if you give us money now, these people, when they pay us, we'll just give it to you. You know what I mean? So they are using the contracts in a financial way to where they are getting money ahead of time, right? They're getting credit ahead of time, but they're using the contracts. Now, that contract is a piece of property that they're using as a benefit. And if that's your contract, they're using your property. But now let's say it's no longer your property. Let's say you took the rights of those contracts and you transferred it, sold it, conveyed it, signed it, whatever, to a trust. Now the trust is the owner of those rights. Now the trust is saying, it can look at that conduct of the utility company and say, hey, wait a minute, you're using a piece of property that belongs to the trust. That's an asset, man, that belongs to my beneficiaries, and you're using it and you're making a little bit of interest and you're making a little bit of profit from that. You're getting capital ahead of time by using the contract that belongs to me and my beneficiaries. Hey man, you can't be using a benefit without giving me any interest. So obviously the trust can then make a claim and say, hey BL, check this out, you're using a contract as a negotiable instrument. You went to negotiate that contract. So you use the contract as a negotiable instrument. Negotiable instruments are forms of money. So you used it as money. So you're benefiting from that contract in the same way that my person is benefiting from your service. My person, John Doe account, blah blah blah, 1 2 3 4 5 of Belize Electricity Limited has to pay you because it's taking a benefit from you, so it has to pay you something. So it's only right that you're using a contract that's supposed to benefit financially my person, but you're using it and you're not giving anything in return. So check this out, I need you to give me the interest owed to me, but I don't want you to give it to me cash. I want you to apply that to the account right here at BEL. For this person right here, I want you to set off this account. Use the interest that you owe me for my contract that you use. I want you to use that, apply that interest over here on this account right here, so you can set it off. So this is how basically the set off works, and the discharge of obligations and discharge of debt. So this is why when we look at this, we can see that the original signature, the John Doe of the account that signed the contract, may not have been informed or compensated, right? Because they don't tell people this, they don't have to. Now if the man chooses to express a trust relationship, he may assert it. Now let's say you signed the contract, right? Now most of us sign that contract and say, yes, I would like your service, Mr. BEL, and here's the contract, you can have it. We don't tell them, express anything, any rights. Say we just hand over the contract and they get to use it how they want. Now, but what we can do is we can turn that piece of paper around. This is not legal advice. But I'm just saying this is what we can do. We have the right to express our knowledge of how the financial system works. We can express our rights on what we want done with what we are conveying to them. So we know that they can use that contract in a financial way. So we'll say, hey, you know what? For value received, meaning for interest received, I, the living man, assign all rights, title, and interest of this here note, right here, this note right here, to the electric company, to you, BEL, for the benefit of John Doe account 1122112222, whatever, right? So again, that is creating a trust. So this converts the instrument from a simple contract to a trust instrument, because now it has both the agreements, a signed signature of a debtor or somebody representing the debtor agreeing to pay, making that instrument a commercial instrument that outlines an obligation to pay. Okay, fine, but now that there's an obligation, how do you secure it? Well, turn it around, convert it into a trust, and now you're going to say, look, this, I'm giving you now this instrument here, which is a which you can negotiate. Use it as a negotiable instrument. Go ahead. I'm not stopping you. Do your thing. You take this instrument and plug it into the securities market and do whatever you need to do to make more money. But guess what? That's a benefit that you're going to get. And I need you to compensate me, because I only represent the beneficiary of that instrument. And I want you to use that instrument as efficiently as possible. I want you to make $1 billion out of it. I don't give a damn what you make out of it. But I want you to use the interest you owe me to set off the account of John Doe account number 11221122, whatever. So now you create the obligation on one side and you secure it with a trust agreement on the other side. So that's the security of the obligation. And once you create that, then now we can go over and create a trust. We can register that or record it as a trust deed, because once we hand over that promissory note or that instrument, that creates a transfer and a trust agreement. And because it is transferring interest, it creates a trust deed. Now we can go over to the court and we can record that trust deed, and then that actually shows on record that there is a trust agreement between the man or the one who represents the man. The man with the utility company, or with the trust and the utility company. And then what we do is we go and we then register a security right, which is equivalent to a UCC1. And we're going to say, hey, well, there's a lien. Right now there's a lien. And the lien is basically the utility company is getting a lead on the account. The lien is the only, the utility company is being granted a right to charge the account, but simply because it has been given a security, a collateral for it to then settle the account. So that's why when we go and we record that security right, after recording the trust deed, that securitization or securing the right is what you call perfection of security interest. Look it up. Now 7, implication of dual ledgering. Now this fiduciary commercial structure implies two ledgers. Now we're talking about accounting, because see, you create the account, right? You create the obligation, we sign the contract that creates an obligation between the person and the utility company. That's one side of the ledger. That's a commercial ledger. It tracks the payment, obligations, and services rendered by the utility company to the person, and now the person is a debtor, and in that case the BEL, the electric company, is the creditor. But then this creates another ledger, because now you created a trust. Now there's a trust agreement. Now there's an asset that is being that must be ledgered into the account, which is the collateral. So now the fiduciary ledger will track beneficial rights, capital creation, and securitization. So now the fiduciary, basically now they're going to use that contract and negotiate it to create debentures. They're going to get interest on that. Well, that's going to create interest. That interest needs to go and adjust that commercial ledger, because now we have a double what's it called? A double bookkeeping, matching principle. So when these two ledgers are not reconciled, right? When they're not reconciled and the beneficial interest is not acknowledged, the man's rights are not fully expressed or protected. That's because we don't do what we need to do in order to secure those obligations of our person. So now the property, which is contract rights, may then be treated as abandoned when we don't do all of that. When we don't create that trust deed, and when we don't secure that security right, when we don't register that security right. So we don't have a perfected security. We don't have a perfected security interest on that. So even if equity would suggest otherwise, it looks like we abandon our rights if we don't do that. So legally, they can do whatever the hell they want with it then, and they don't have to inform us of anything. Now, if there were ethical business with moral people running it, then they might say, hey, you know what, you need to probably do steps A through Z so that you don't have to pay this out of your pocket, and we can just settle the account using the instrument you gave us. But that's not what's happening, so that's what we want to work on. So now 8, the role of public authorities. Public authorities must understand when fiduciary obligations arise. I think they should, but they don't know that right now. I know, because I've created so many trusts with them. They just they're not cooperating. They don't even think that it's possible until I get it recorded in the high court. They're like, what's going on? And right now I'm actually in the process of recording a security right on the government of Belize, appointing them as fiduciary for certain obligations that they must fulfill regarding the person on that birth certificate, and in regards to also the social security person. So they must understand when fiduciary obligations arise and how they are the responsible party, because they actually are the ones who are volunteering to be public officials. Nobody's putting a gun in there and say you gotta be a public official. No, they said I want to be a public. Okay, if you're a public official, then you're open to public trust, and you're open to the people entrusting you with certain rights, duties, and freedoms, in which unfortunately, because you've already agreed to it, you're very volunteer to it, equity will not aid a volunteer. That's another maximum of equity. So acknowledge the equitable claims. That's what they need to understand too. Public authorities must acknowledge equitable claims. And I think they must first understand it. I don't think they understand it. Most of these politicians, they don't need to know the law to get to the position where they are. They just need to know customs, the customary procedures of doing things here. They don't need to know law. They just don't. They just need to be a little bit, and then as soon as they enter politics, they even start to talk different. It's like they go through a training, that tells them how to speak and all that. It's very interesting how they do. But another thing that they must do is uphold transparency in how contracts are used, especially when securitized. Again, I don't think they understand how this works either. This is a matter of trust law, constitutional duty, and public entity ethics. Yeah, there's probably some noise in the background right now. I have somebody constructing, so I'm sorry about that. So this is the recommendations 9. This is the recommendations that I'm saying that we should do is education of public officials in trust and equity principles. I think this is a must. Public officials should know about trust. I've spoken to lawyers and attorneys right here in Belize, criminal attorneys, and they I don't know if they're lying or not, but they told me they don't know anything about trust. I asked them about trust. They don't know much about it. I don't know if that's true or not, but that's what literally comes out of their mouth. And I asked them questions and they just don't know. Or maybe I haven't paid them for a consultation enough to know. Who knows? But I don't think they know. So another thing is acknowledgement of express trust when declared. So when I send documentations and I create a trust and I transfer rights title and interest to a certain instrument, these public officials don't know what to do, and they don't understand that by not responding to the stipulations, to the document that has stipulated that if you don't respond, this will be understood as and interpreted as an acceptance, and they don't respond still, so they don't understand it. And again, education is necessary. They don't know. I don't think they know. These poor people are, government educated just like everybody else. They don't know unless they're probably in small circles who know, and then they're probably going to lie till the day they die about it, because it's just part of their circle. And another thing is legislative reform. Number 3, to ensure fiduciary practices in handling contracts and financial assets. Actually, there's already legislation for that. I think it should be legislative acknowledgement. That's what I should have put here, legislative acknowledgement. But it should be reformed in such a way that it's easily understood. Right now, it's very difficult to understand this. It's there, it's right there in the acts, but it's a little bit complicated. You really need to know some background knowledge of other parts of law in order for you to see and recognize that the legislation acts already includes everything, because the legislative acts has to reflect equity, has to. But then you got to find out where it is in the million pages of code that exists, right? Another thing too, number 4, is the creation of beneficiary disclosure rules for public-private contracts. Yeah, that would be nice, because I don't think it is understood that these contracts, off the back, they don't understand that these contracts, when used as a financial asset, there now is a beneficial right to the owner of those contracts. Now, I think they know. I'm pretty sure they know in such a way, but I don't think they believe that it is possible for the one who signed the contract to have those rights and then sell it to some other entity, and that entity claim those rights in such a way that they can utilize that contract as a security and collateral. I don't think they understand that. That's a little bit difficult to understand. I get it. So creating beneficiary disclosure rules on the contracts would be a plus. And another thing is adapting a double ledger system. We already have the framework for that. If you look at if you read these financial orders and you read how this how the accountability, or how the accounts of the tax department, the treasury, there is already a double ledger system. However, it doesn't seem to be available or utilized in this manner. It seems that the only one privy to that is government. Only the government can have the right to utilize a double ledger system. And you know what I mean? That's what I feel. I could be wrong. But it would be nice to see that full adoption of it. Now, in conclusion, governments and institutions operate under public trust. This is true. Every man and woman who contributes their labor into the system. Listen to that. Every man or woman who contributes their labor, their substance, their gold into the system has a right to transparency and fairness in how their contracts and how their energies are converted, securitized, and utilized, monetized. To preserve public confidence and uphold justice, we must honor the fundamental truth. All value originates from labor. That's a fundamental truth. All value originates from labor. I mean, what value does gold have if it's still on the ground in the soil, just right there, just chilling? It takes labor to go and dig it out, clean it, and convert it into usable things. Labor needs to go and do all of that. Without labor, gold, silver, mercury, iron, diamonds, they're just soil, pieces of the soil, parts of the soil. They're nothing. Labor is the original source of value. Then everything, forms of value, types of value, things that represent it, come after. Money is subordinate to labor. I'll give you an example. I have 1,000 new Belize dollars. and I go to some country, maybe in India, and I want to exchange this $1,000 for something to eat, they're gonna look at that dollar bill and I don't want that crap. I don't know what to do with it. Okay, now how about labor? Yeah, well, I'll take labor. Labor is fine. Labor is universal, right? It's the original value. So now this truth grounds the legitimacy of all currencies, all contracts, and all trusts. So what I am suggesting is for us to return to first principles, that the power of the crown is fiduciary. They are a fiduciary obligated body of trustees that govern in the public trust, as a public trust, and that all legal instruments must ultimately serve the people. All legal and commercial instruments must serve the people from whom all value originates. So anyway, I wrote this on this date right here, and I wanted to share this with the public. If you've watched all the way to the end, thank you very much for watching. Thank you for supporting. Thank you for following. And I hope you can share this. Share it with a public official. Share it with a public officer, with a police officer, with somebody who works at the bank, somebody who works at the Ministry of Finance. Share it with anybody you want to. Share it. Let them learn. They need to learn, and you need to learn. All of us need to learn this. We shouldn't be paying anything out of our pocket, because it's already you can't pay anything with promises to pay. First of all, you cannot pay with a promise. You can satisfy the obligation, you can settle it with some form of security, but you can't pay anything with a promise. And that's all we're offering right now, each other in the public and in the private, is these pieces of paper, promissory notes. It's just a promise. You cannot pay something with a promise. So this is why we're not supposed to pay anything, but we can utilize the beneficial rights that we have to our labor, that we're contributing to this government that is broke. The government has no gold and silver. It's broke. Everything it offers to secure. Now it doesn't have anything. So we provide the value. So we are supposed to be the rightful parties of beneficial interest and beneficial rights. So thank you again for watching. Peace, love, and law. Until next time.